Here's a question we're sitting with. What's your company actually worth? Most business owners will answer that in terms of revenue, assets, market share. But for a growing number of companies, particularly in technology, media, entertainment, and consumer products, the honest answer is that the brand lives somewhere in something you can't see. It's on your balance sheet, and that's called goodwill. That's your brand, your patents, your trade secrets, your copyrighted protected work. It's all about your intellectual property. And here's the thing about IP. If you don't know what you have, you can't protect it. And if you can't protect it, someone else can use it, copy it, or beat you to market with it. And once that happens, it can be hard to get back what you've lost. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by my partner, Richard Buckley. We're going to do a full IP bootcamp on today's installment of the briefing. Richard, welcome back to the briefing.
Thank you, Scott. Looking forward to Bootcamp.
Bootcamp. We're going to do Bootcamp today, IP Bootcamp. All right. So today's a big picture episode. We are going to cover intellectual property as a category. So a lot of generalizations and a ton of top level discussion. So what IP is, why it matters, and how the four main branches, trademarks, patents, copyrights, trade secrets, each protect different types of business values. This is the kind of foundational overview that I wish every business owner had before they were sitting across the table from a plaintiff's lawyer.
Right, because by the time a lawsuit is filed, a lot of these problems could have been prevented with some basic housekeeping.
All right, let's start with the concept itself. Intellectual property refers to intangible assets, things your company owns that you can't necessarily touch or hold, but that have real economic value. In many businesses, IP assets drive the majority of total company value. I like to talk about Coca-Cola, right? The value of Coca-Cola is not in the buildings, it's not in all the trucks, it's not in all of the fancy bottling equipment. It is in two things. It's in the trade secret for the recipe for Coca-Cola, and it's in the Coca-Cola brand. That's where the real value sits.
And what I hear a lot is that clients don't think of these as a portfolio. They treat each type of IP separately, or they don't think about it at all until they're in a dispute or heading into a transaction. At that point, we're often helping them clean up problems that could have been avoided years earlier.
Right, that's exactly right. And owning IP doesn't just protect you in litigation. It creates strategic value. It raises barriers to entry for competitors. It gives you negotiating leverage with suppliers and customers. It can reduce competitive threats just by the fact that your IP exists. And for a company thinking about a future sale or investment round, a clean, well-protected IP portfolio is one of the most valuable things you can show your buyer. So why don't we get into the four categories? Why don't you kick us off, Richard?
Trademarks. Trademarks protect your brand, your name, your logo, your trade dress. Patents protect inventions. Copyrights protect original creative works. And finally, trade secrets protect confidential business information. Let's go through each.
So let's start with trademarks first, because this is the intellectual property, the piece of IP that most businesses encounter, and actually most consumers encounter earliest. A trademark is any word, name, symbol, logo, or even a sound or a color or a scent that identifies the source of goods or services and distinguishes them from competitors. Trademark law protects the goodwill associated with that brand. Now, not all marks are created equal. At the strong end of the spectrum, you've got a fanciful mark. That's a coin word like Google. It has no meaning outside of the brand. And then you have an arbitrary mark like Apple for computers. Those get the strongest level of protection. Then you've got suggestive marks. Those are the ones they sit in the middle between your your fanciful and your coined marks, and those are distinctive, and the marks that are descriptive and really aren't protectable at all. So the suggestive marks, they sit in the middle and they hint at the product's qualities, but they don't tell you what they are. A descriptive mark, like for example, Tahoe Plumbing, they're harder to protect because they tell you exactly what the services are all about. They need to acquire distinctiveness in the market before they'll be protected. And generic terms, well, they can't be protected at all. A generic term is something like A1 or the best.
This comes up constantly in deal work. A company that's been building a brand for 5 years shows up to a transaction, and we find out during diligence that their mark conflicts with an existing registration. At that point, the options are not good. A full clearance search before you adopt the mark changes that conversation entirely.
Right. And a full search means more than just running your name through the USPTO database or through Google. A full search needs to cover federal registration, state registration, common law usage, domain names, uh, business name databases, and maybe other industry databases, because the common law user who never registered the mark is usually the one that comes up and causes all the trouble. They still have rights in their market. So once you've adopted a mark, you got to get it registered. You got to police it and grant permission in writing with quality control provisions, because a naked license, it's not as sexy as it sounds. That's where you let someone else use your mark without any control over how they use it. That can actually lead to you losing your mark entirely.
Indeed. Let's move to patents. Patents are the IP type I think clients understand least intuitively. They know the word, but they're often unclear on what actually qualifies or what they're giving up. So at the most basic level, patents protect inventions, new, useful, and non-obvious processes, machines, compositions of matter. The government grants you the right to exclude everyone else from making, using, selling, or importing your invention for 20 years from the filing date. Design patents, which protect the ornamental appearance of a product, get 15 years from the date of grant.
Right. And the critical thing about patents is the trade-off. You have to publicly disclose the invention. That's the bargain with the government. You may get 20 years of exclusivity, but the public gets to know that knowledge after that, and they get to use that knowledge after your patent expires. Now, the United States is a first to file system, which means that speed matters enormously. If you're working on an invention and a competitor files before you do, and they get the patent, even if you invented it first, well, that's problematic. A provisional patent application is a critical tool here. They lock in your priority date and they give you 12 months to continue developing and testing before you have to file the full application.
So Scott, turning to copyright, copyright is where I think a lot of our entertainment and media clients get into trouble, partly because the protection is automatic, which leads people to underestimate the steps they still need to take. So the baseline, copyright protects original works of authorship fixed in a tangible medium, articles, software, websites, photographs, audiovisual works, databases. The moment you create and fix the work, you have a copyright. No registration required for the protection itself.
Right. But registration is what makes the protection enforceable in a way that actually matters. Without timely registration, meaning before the infringement commences or within 3 months of first publication, you cannot recover statutory damages or attorney's fees. And those are often the only remedies that make enforcement commercially viable and, frankly, give you leverage over the infringer. The big ownership issue for businesses is the work for hire doctrine. If you commission creative work from an independent contractor, software, graphic designer, website content, author, whatever, you do not automatically own the copyright just because you paid for it. You need a written work for hire agreement or a written assignment, or as I prefer, an agreement that has both a work made for hire provision and an assignment, this catches companies completely off guard. And I might add also, if the person doing the creating is not an employee, the creating the work in the course and scope of their employment, then you most definitely need a written agreement that has the work made for hire language and has a written assignment.
You mentioned software, and I think the software situation deserves its own emphasis. A lot of companies assume a standard services agreement covers them. It often doesn't. If there's no explicit assignment or work for hire language, the developer of the software may retain the copyright in the code they wrote for you.
Right. That's extremely problematic. All right. Can you imagine the situation? Well, I mean, I've been there actually. We've been involved in situations where that's a very hard conversation to have with a client, and it usually results in prolonged litigation. Okay, let's talk about trade secrets.
Mhm.
These are incredibly valuable precisely because they can last indefinitely as long as the secret holder keeps them secret. A trade secret is any information, a formula, like I said, the formula to Coca-Cola, a process, a customer list, a pricing algorithm, a manufacturing method that derives independent economic value from not being generally known and that you take reasonable steps to protect. As I said, the Coca-Cola formula, it's a classic example. No registration, no public disclosure, no expiration date. The flip side is if the secret gets out through employee disclosure, a security breach, or someone independently developing the same thing, your protection is gone. You may have a trade secret infringement case, but the protection is probably gone. And reverse engineering of a lawfully obtained product is not trade secret misappropriation.
The California piece here is worth underscoring. We see clients assume that a non-compete clause is doing the work that trade secret policy should be doing. California broadly prohibits non-competes under Business and Professions Code Section 16600. But that prohibition does not protect a departing employee who walks out with your trade secrets. Those are two completely different legal issues, and you need both addressed explicitly.
Right, right. Non-disclosure agreements with employees and contractors need to know access controls, proprietary rights agreements, clear marking of what is and what isn't confidential. And when a key employee leaves for a competitor, that's the moment you need to be most alert to trade secret risks.
So let's bring this down to earth for the business owner or the executive who's listening. The starting point, in my experience, is always the same. Know what you have. Do a complete audit of your IP assets, your trademarks, your patents, if you have any, your copyrights, your trade secrets, what's registered, what's not, what's licensed, what's exposed. That audit is the foundation, and it should happen well before you're heading into a deal or a dispute. From there, get your agreements right from day one. Proprietary rights agreements with employees, these should require assignment of inventions and copyrightable works created in the scope of employment. They should also have clear confidentiality obligations. Written agreements with every independent contractor that explicitly address ownership. This is housekeeping, but it is the kind of housekeeping that determines whether you actually own what you think you own.
Right. On the brand side, search before you adopt. Register once you've cleared. Monitor for infringement and respond when you find it, and respond in an appropriate manner. And I'm going to say, respond only if you're serious about pursuing an infringement action if you don't get a suitable and acceptable response from the alleged infringer. There's actually nothing worse than sending out a bunch of cease and desist letters and not doing any follow-up. Don't grant oral permissions to use your trademark. Put it in writing with quality control provisions. This is how you build a brand that is defensible. And one thing business owners don't think about enough, IP insurance, right? IP litigation is expensive. Errors and omission insurance covers certain types of IP specific claims. And this can be the difference between a company actually surviving a lawsuit or being destroyed by the cost of defending one.
The bottom line is this: intellectual property is not a legal niche. It's a business asset, and it deserves the same strategic attention as any other major asset that your company holds.
Richard, well said. Well, that's going to do it for today. Thanks again to my co-host, Richard Buckley. Richard, always great to have your insights. And thank you to our listeners for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.